Hello, my name is Muhammad Izzat bin Razani, and today I will be presenting a significant employment law case involving Dr. Nur Adila binti Chegani, a medical doctor who was employed by City Healthcare Sdn Berhad since 1 March 2022. She claimed that she was constructively dismissed by her employer on 18 September 2023 due to several persistent breach of her employment contract. Among her main grievances, the first one is repeated delays in salary payment from May to July 2023. The second one, non-payment of statutory contributions to EPF, SOCSO, and ACE. And the third one, failure to remit PCB, which is income tax, to the Inland Revenue Board despite salary deductions. Despite repeated requests and the issuance of a formal notice of breach of contract dated 8 September 2023, the company failed to remedy the issues. This compelled the claimant to resign by treating herself as constructively dismissed. During court proceedings, the Industrial Court found in favor of Dr. Nur Adila and declared that she had been constructively dismissed without just cause or excuse. As a remedy, the court ordered City Healthcare to pay 66,300 in back wages, which is after a 35% deduction from post-demission income, and 8,500 as compensation in lieu of reinstatement. The total award was 74,800 to be paid within 3 consecutive months, which is 30 days. For the issue of the case, the first one is late salary payment. The company habitually delayed paying the claimant's salary between May and July 2023. According to Section 19 of the Employment Act 1955, salary must be paid within 7 days after the wage period. The repeated delay, breach of the employment contract and statutory law, leading to financial insecurity and erosion of trust. The second one is non-payment of statutory contributions. Despite deducting the claimant's share from her salary, the company failed to remit EPF, SOCSO, and ACE contributions. This violates Section 43(1) EPF Act 1991, Section 6(1) SOCSO Act 1969, and also Section 18(1) ACE Act 2017. This not only breached the employment contract but also broke the law. And the last one is failure to remit PCB, the income tax. The company deducted monthly PCB from the claimant's salary but did not remit it to the Inland Revenue Board. This further violated the trust expected in an employer-to-employee relationship and constituted a serious statutory and contractual breach. The court found that all three breaches taken together amount to a consecutive dismissal. The claimant had no reasonable option but to resign.
Hai, Assalamualaikum warahmatullahi wabarakatuh and selamat sejahtera. My name Muhammad Dani Imran bin Safawi, and now I will answer the question C, which is a related act and law, and this case is deeply tied to several key employment law in Malaysia. I will give the three answers, but the first one is Industrial Relation Act 1967, subsection IRA, Section 20, subsection 3. Its employees allowed to file a complaint of unfair dismissal. The second one is Section 29 Submission D empowers the court to proceed even in the absence of parties who fail to submit pleading. The court is used this section to determine the case and proceed despite the company's absence. Number 2, Employment Act 1955 Section 19 Subsection 1 requires salary to be paid no late than the 7th day after the wages period. And then the section 24 and 25 government lawful salary deduction and mandate that they must be remitted promptly. And then the last is about EPF Act 1991, SOCSO Act 1969, and EIS Act 2017. This act legally require both employer and employee contribution. Failure to comply is a criminal offence and breaches contractual obligation. The court emphasized that statutory contribution are non-negotiable obligation and any failure contractual are fundamental branch. Now, I will give the answer for the D question about group comment about the pro and cons about this article. So for the pros answer is about legal clarity. Legal clarity is about the decision reinforce employees might under Malaysian labour law. It shows that statutory compliance is not optional. And then protection against exploitation. Workers now have a clear path to seek justice when their basic rights are violated. And then judicial fairness. The court proceed fairly despite the employer's absence, relying on fact and document evidence. Now, for the cons about the article is employer negligence. The company's failure to respond or defend themselves weaken the case of a balanced hearing. And then delays in remedy. The process took over a year from reference to award. Employers in similar situation might suffer financial distress in the meantime. And then the breakdown of relationship. Even if reinstatement was possible, the relationship had already deteriorated, making a return to work impossible. The court ruling is just, but the non-compliance by the employer also raised concern about enforcement and governments in smaller or private firms.
Hi, my name is Yusuf Shahmi and I want to talk about solution to prevent recurrence. First, strengthen HR and payroll system. Implement automated payroll systems and reminder to ensure timely salary payments and statutory contribution like EPF and SOCSO. Second, regular audits. Conduct quarterly internal audits and allow external bodies to perform random compliance checks. Third, training and awareness. HR staff should attend labor law workshops, educate employees on how to monitor their contribution. Example, KWSP and I-account. Fourth, escalation channels. Establish internal grievance and whistleblower system. Provide early dispute resolution option like mediation. The last one is government oversight. Enforce stricter penalties for non-compliance. Introduce a blacklist for repeated offenders to ensure accountability. The conclusion is, first, employer failed in multiple obligations. Second, employee rightfully treated herself as dismissed. Third, court decision reinforces legal protections. And lastly, prevention is better than litigation. Compliance is key. Thank you.